Welcome back to Always Ageless, the show where we are your resource for aging adults and the adult children of aging parents, and where we bring information so that you can live a life based on knowledge, not crisis. Today's episode is a little different, and it's so important. We're diving into a topic that most people avoid until it's too late, but not you and not today. Because whether you're a senior or the adult child of aging parents, or you're just someone who's worked really hard and you'd kind of like to protect what you built, you'll want to lean in for this one because our guest is attorney Harry Barth. He's a nationally recognized attorney in the fields of estate planning and asset protection. And what I like is that he's an asset protection advocate, and we all want an advocate, don't we? So as an author, a sought after speaker, he's helped thousands of families and businesses across the country. And Harry, I don't know if you know this, I was actually referred to you by another attorney, an attorney in San Diego, actually. And if my audience is like me, you always wonder who you can trust and who's really going to look out for you. All the ads say we're going to take care of you, but who really is going to watch out for you? And you want to feel from the very beginning that they're going to have your best interest at heart. So we immediately felt in our first conversation with Harry that he was the person for us, that he listened to us, and the good, the bad, the ugly, we could tell him, and he will work with us, and he would tell us what was the best thing for our family. So I knew then that I wanted to share him with you, my audience, my viewers, and my listeners, as well as with my own clients. Now, I know that estate planning doesn't sound like the most thrilling summertime topic, but trust me, he makes it not only approachable, he makes it urgent, empowering, but even entertaining. You're going to love listening to him, and you may even chuckle at a few of his stories. I know I do. In the next few minutes, you're going to hear why you don't have to be wealthy to need a plan, how you can keep from losing everything by just having a little protection, and the simple steps that you can take starting today to ensure peace of mind and dignity and control for the years ahead. And we all want to have control of our own situation, don't we? So grab your coffee. If you're driving, roll up your windows and turn up the volume, because you're going to love this conversation and it may change everything for you. Welcome, Harry Barth, to Always Ageless.
Happy to be here, Valerie. Sounds really good. I'll give you $20 for that introduction. Sounds great.
Good. I don't know. I've listened to you. You're a great speaker, and I could listen to you for a long time. I know I listened to you at a place where you had been invited back, you said, for multiple years, and it's no surprise why you're invited back. You're entertaining and delightful, and obviously, you know a lot about what you're talking about, what your field is. So let's talk about you a little bit. I'd like to know, and I know our audience would like to know a little bit, how did you choose this field? And was it something you started in, or did you decide halfway? So many of us have a story where, life was this way and then something happened and we changed.
Yeah,
What about you?
not really. So for me, I started when Moses came down the mountain. So
Okay.
it's been a very, very long time. I've been at this, Valerie, for about 50 years. I'm a licensed attorney in California, in New York, in Washington, the District of Columbia, and amongst other jurisdictions. We have just a little background. We've got about 11,000 clients from coast to coast. I have 20 attorneys that work for me. And this is what we do. Now, how did I get to this is what we do? So I remember it's a very interesting story. Back in 1969, all right, I had just finished graduating college, and I needed a job. All right, I was married in 1969. I've been married 57 years now, 10 of them happily, and I needed a job.
Yeah.
So I went to an employment agency, and they turned around and said, "Hey," I said, "I want a desk job." So they turned around and said, "Okay, well, we have a nice desk job for you, selling life insurance for the Prudential Insurance Company." And I didn't even know what a life insurance policy was. I was a young snot-nosed kid. I was all of like 20 years old, and and I said, "Oh, okay, fine. Whatever you got to do, you got to do." So it was my first introduction back into risk management. I was dealing at a very, very young age with what happens when somebody passes? When you're 20 years old, somebody passes. It seemed like into the future, and the dynamic impact on the family. So at a very young age, I began to delve into risk management and estate issues, um, and it just continued. And then I realized along the way that when I went to law school and I got out, I never worked for anybody else. I just started, Valerie, right with estate planning and asset protection. But why asset protection? Well, I thought about it this way. I said estate planning was one aspect of asset protection. It was protecting assets from the government, taking it away in taxation. It was protecting assets from being publicly exposed through a probate process. It was protecting assets from family infighting, which we're going to talk more about today. And then,
Yes, we probably will get into
yeah,
that.
and then the other thing I said is that I saw so many, even at a young age, I saw so many people that had spent time, effort, and money putting together a plan for their death or their incapacity. And then I saw those people who had gotten in trouble because they crashed their car, or they signed a personal guarantee, or they had a business dispute or a fiduciary problem, and there was no assets left to distribute to the family. So I said, actually, what asset protection is lifetime estate planning to build and protect the estate. And then as the estate planning was dealing with the distribution of that upon our passing. So the two intertwined, and I'm probably the one of the, we'll call it the grandfather of that intertwining of which we're going to talk about today, the interrelationship between asset protection and estate planning. And when we talk about asset protection, there's always, Valerie, a very simple adage. Who doesn't want to protect their assets? Who says, no, I don't want to protect my assets. I don't care if I have a house. I don't care if I have money in the bank. I want it to be able to be taken away without any problems, no issues. Everybody wants to protect their assets. The difference is that it gets down to how. What does it cost? What are the restrictions? You know, how do I go about doing it? And most people don't know. And today, hopefully, everyone's going to learn a lot more about the basics of asset protection planning. But look at it as a subset. So asset protection planning is look at it as the top level. And then look at, which we'll see today, that estate planning is a subset of asset protection planning. Let's look at that income tax planning is a subset of protecting assets again from the tax man. And let's look at even investment diversification in the financial world. Not all thine eggs in one basket is asset protection. Let's think about this whenever we buy homeowners insurance, whenever we buy life insurance, whenever we buy automobile insurance, it's asset protection. Asset protection is just human. We need to do that. So we're going to learn about the intertwine between the two. So I got started, not from somebody else. There was no special event, nothing. It's just something I felt was critically important, and I've been a leader in that particular field ever since.
You have. You have been a leader. You have been, and a highly respected one at that. So, of all of the things that you've done, all the people you've helped, what have you learned from all of this that has really surprised you?
What's really surprised me, I'll give you an example. I'm surprised every day. All right. Humans are complex. Our thoughts about all the things we just spoke about are complex and come from our experiences that lead us to who we are and the decisions that we make. Literally, the other day, I was working with a new client whose net worth, Mallory, was north of $300 million
Jeez.
and did not even have a simple will or a simple trust. Absolutely nothing. That surprised me. Everybody thinks when you have individuals who are wealthy and savvy and they'd be able to make a fortune that they would have all the attendant things that go around that, and the answer is no. And that continues to amaze me. And of course, they're working on it now with us. We're getting it all fixed up, but that really does amaze me. And the other thing that amazes me is that uh, people, when we talk about estate planning today, I'd like, as you said, yeah, how boring can estate planning be? And so let's just use another analogy. And this is an interesting analogy. So Valerie, let's go into a theater, okay? And the stage is lit, and you and I are sitting in the audience, and we have in our hands a script, all right, that we wrote. And up on the stage is your husband, your children, your parents, your siblings, people that work for you, all right, are all up on the stage. They're actors on the stage. And we are going to write the script of how that play is going to play out in the event that we are out. And it's not a clinical legal document, it's the script of family culture and values. Now, if we want to have two children and we want to make them fight, we can make them fight. If we want them to be amicable, we can make them amicable. If we have one that spends too much money and one that doesn't, how do we rectify that? We can do that in the script that you and I write. It's a critically important document. And the other thing that's always surprising to me, and I think all of our listeners will understand this, when we do a lot of mergers and acquisitions and commercial transactions and real estate contracts, some of the areas that you're familiar with. And the lawyers, all right, are sitting there and they are redlining every paragraph. Change the word from us to we. Change, the word from may to should or shall to should. And they go through and micro read every word of every line, trying to improve that contract. And the lawyers are busy and people are paying legal fees to get it done. Now, one's family trust, basic estate planning tool, and really basic, and we'll talk about that today. People rush in to the lawyer's office, the ones that even do it, rush out of the lawyer's office, kind of put together something that's boilerplate, something that, I can tell you that 65% of them look like because they all look the same. Yet, this contract is a contract that transfers a lifetime's worth of everything, that commercial building, that business, that factory, everything, that brokerage account to the next generation and how it's transferred. To me, most likely the most important contract with the least amount of interaction, and a much more minor contract has 10 lawyers around it governing each and every word. We don't see that. So that's an interesting phenomenon that hopefully we'll dispel today to make sure that we understand that these documents are not clinical legal documents. These documents are very personal documents. And when you ask me a question, which I'm sure you will along the way, about healthcare directives and things of that nature, we'll talk about the nature of that. And I think for all of us, this is, your program is dedicated towards seniors and children of seniors. Matter of fact, let me just go off on a tangent for a half second,
Sure.
about one thing. And we deal with, if part of an estate planning package, we have a simple thing that people think is, they just don't give it much thought, an advanced healthcare directive.
Right.
Then you say, don't give it much thought. Here I am giving somebody the right, literally, to terminate my life. Here I am giving somebody the right to withdraw feeding from me or water. I'm giving someone the right to put me into a long-term care facility. I'm giving somebody the right to hire somebody who's going to wipe my butt. How more personal can we get than that? It, this is a, this is a document that becomes functional when we are no longer capable of functioning on our own. In other words, we can't make these decisions, so we're entrusting other people to make them for us. I can't. That's a really powerful document, and it's a really highly personal document. And what do I say? We see these forms, sign here, sign there.
Yeah.
I think that needs to be well thought out, well done. These are the things that I find so different in today's world. In that, people, I think what we want to do today, Valerie, is dispel the fact that these are clinical legal documents. These are cultural, personal, emotional things that really uh, stand for a lot of what we have stood for while we're on Earth. And I think we need to give it, it doesn't cost any more to give it its due. Um, but that's one of the things we want to get across, that we don't avoid these issues. For example, if Valerie, if we don't have an advanced healthcare directive, we do. It's written by the state of California for us. We have to go to court. We have to get a conservatorship. We have to spend $25,000. We have to have people arguing left and right. It could destroy a family. All right. Um, because we didn't take the time to put together a comprehensive document that deals in those areas. I'll shut up and you can ask questions.
No, that's well, that answer. That's basically it in a nutshell. All of those things. And so where do we start? Sure. And how do you bring? The questions today are: how do you bring families together? How do you keep them apart? Sometimes, maybe it. But let's talk about. So, what do you think? The biggest misconception I think is that. Here you have a client that's high wealth, high net worth person, and just didn't get around to it. We have a close family member, the same situation. And how is it that of all the things we think about in our lives and we think are important, that we don't think that's important? And in what we're doing now as a senior home coach and a senior specialist is try to help people to realize they need to make decisions before it becomes a crisis, right? Before they get the call. And I heard you speaking once about the calls that you get and then it's too late. And we say, you
Especially
can
in
go
the
on.
asset protection arena.
Yeah,
Yeah.
absolutely. And you go on with life forever. And then something happens, right? There's a fall or somebody has an accident. You talk about somebody crashed a car and then here's the call. And then
Oh, yeah.
everything needs to step into place. And, oh, Harry, what can you do to save me? Right. How do you, and now I know I should have come, Harry. I know I was supposed to, I know we had an appointment, right? And I missed it. I'm so sorry. I got busy. And now, Harry, you're supposed to be their hero. So let's talk about the misconceptions that people have. So let's talk about what is the difference between a will and a living trust.
Sure.
Do people know
So
that? And are those really important?
yeah, that's a very big misconception. So let's clarify that. So people say, well, I have a will, some people say I have a trust, and there are a lot of things that are around that, and many more things than we will have time to talk about today. Um, so what's really important, Val, is to let everybody know that who's listening to your show that they can get a complimentary consultation with a member of my team, truly complimentary, to answer any further follow-up questions that come as a result of our conversation today.
Right.
So first, let's understand one of the things is that there are a couple of different systems by the way in which assets. We're going to deal with incapacity in this as well, but let's deal with death. All right. So there are a couple of different systems that we have that enable us to legally transfer assets from people who have passed to their heirs. So that's the bridge. We're bridging Gen 1 to Gen 2. And there are tools that are used to do that. Now, in the absence of tools, no tools, no wills, no trusts, people still pass without wills and without trusts. My fellow with 300 million could have passed with no wills, no trusts. So that means we've said, well, maybe we do have a will, and except it's written for us by the state of California. And the process when someone passes to bring the assets from Gen 1 to Gen 2 is called the probate process. It's a public, important, a public process. A process that anyone with 25 cents in a few moments can look at all of Valerie's assets, how they were held, the names of the children, what assets were passing, who we owed money, who we liked, who we didn't like, any children with special needs or disorders. A whole process is public. If everything else I was going to talk about didn't matter, Having that much laundry in the public domain, not a good idea. Now, so understand, in the absence of utilizing appropriate documents, it is all in the public domain, and that's critically awful. Now, the second thing is that probate process is different from state to state. Some states have taken the time to modernize that and make that still a real big pain in the butt, but maybe not as arcane and difficult as some other states make it. California has one of the worst probate systems in America.
Is
Takes
that
the
right?
longest, yeah, takes a long time. We do probates. It's a very big part of our practice,
Uh-huh.
sadly, for people that have passed that don't have documents and or have a will. And we'll talk about that in a second. Um, and the average time that it takes from the beginning of a probate until the time that assets are distributed to the beneficiaries through that 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 silo is 24 to 36 months, 2 to 3 years. So it's all public, 2 to 3 years. Now, the process is very challenging and very difficult. There are probate referees, there are appraisals that are involved. There's just so many steps because the court has now taken on the protection of the beneficiaries and to see to it that the assets move from one generation to the other. And so the court has developed over decades all these arcane rules and hearings to on every little thing, and
Sure.
everything takes 6 months to 7 months to get a hearing. There's not enough people in a black robe to do it. Process is very, very challenging, and so we have costs. It cost on the average 8% of the gross probate estate. So if one had $1 million estate that was moving through probate, more likely between attorney's fees, executor's fees, court fees, and other fees, cost us 80 grand to move
More
that
money.
based on the gross probate estate. So if the only thing I had in the probate, Valerie, was $1 million house, and that $1 million house had an $800,000 mortgage on it. So only $200,000 worth of equity, but the 8% is based on the $1 million.
Oh
So it's
gosh.
$80,000. It's not based on the 200. It's based on the gross probate estate. Okay. So probate is not a friendly place, but it's the only place that we can go to move assets from Gen 1 to Gen 2 in the absence of planning. Now, back to your original question. If one does not have a will, when the assets move from generation one through probate to the heirs, that distribution is proscribed by the state of California. Husband to wife, if it's community property, then divided equally amongst the children. The children get it at age 18, blah, blah, blah. If a child dies at the head of the parent, then the grandchildren. But it's all predetermined by the state of California. The people that are helping the court, okay, are known as personal representatives. The court will appoint a personal representative to work with them. And this is a process which is called intestate, meaning you ain't got no will. All right. So now we got a will. All right. So if we have a will, so what a will does, and here is the first misconception that hopefully all of our listeners will take away, does not, I repeat, does not avoid the probate process. It is a letter of instructions to the probate court judge that when the assets go from Gen 1 to Gen 2 through the court, because it has to go through the court, at the end of that process, the court will distribute that not based on California law, but what was written in the will. So the will says, well, I got 3 kids, one's a bum. All right, I don't want to leave anything to the bum. So the will says, just give it to child 2 and 3, give squat to child 1. That will happen. if the will is not contested, all right, by child number one, which they have a greater opportunity to do in probate court.
Sure.
If there was no will, it would be divided equally amongst the three children because that's California law. So a will is a letter of instructions to a probate court judge. Oh, hallelujah. That does a lot of good. And it also names, instead of the personal representative that was chosen by the court, it names the family members or the people that you would like to work with the court during this probate process. So that's what a will does. So it's a letter of instructions to probate court, but it's just an instructional manual to the judge on what to do. And of course, we've got a million options to contest and change this and do that, all kinds of stuff that are in there. Now, a trust is nothing to do with a will. A will speaks when you're dead. Will has no impact. You die. Now the will has impact.
Okay, so let me just interrupt because I'm sure there are people who are listening and viewing this and saying, but if I have a will, why isn't that enough? Why do I still have to go through the
Because
judge
that's the law.
court?
That's the law. That's what a will does. A will is a letter of instructions to a probate court judge. End of story.
So if you have a will, you still have to have probate.
Absolutely. It's an invitation to probate. That's what it is. That's the difference with the trust. When we create a trust, all right, look at it like a train, all right? And in that train, we make this train put on the tracks. We say what happens to our stuff when, if it's a husband and wife, when husband dies, how is it moved to wife, if there's no husband wife, just children, how it moves to children, the rules, the regulations, all the stuff which could have been in a will is now written in this document called the trust. Anything that's moving through trust is private, does not take 3 years, and avoids the probate process. So
Altogether.
altogether, we have no probate, but there's a catch. Okay, there's a catch that's associated with it. So, but it's private. We know instead of 3 years, maybe we have 9 months worth of administration. Instead of $80,000 of legal fees, maybe we have $15,000 worth of legal fees, and it's private. It's not in the public domain. If everything else, if we say, look, I'm willing to wait 3 years, I'm willing to pay 80 grand. Well, I don't want all my laundry in a public domain.
Yeah, sure.
This avoids that. So so the trust is a probate avoidance tool. It's also the script for the family. Remember our dark theater that we're sitting in? It puts down how we want to move the actors on the stage. But there are two parts, and this is another misnomer and critical for your audience to understand. A lot of people build a trust. They say, oh, if I have a trust, they know enough, this doesn't have to go through probate. But part two is we have to take the passengers and put them on the train to avoid that. So what happens is just having the trust, that legal document that avoids probate, does not help avoid probate if the assets that are moving through the trust have not legally been placed inside the trust. So if I have a bank account,
for example, right? Your
house would be titled in the trust, your bank account would be titled in the trust, your life insurance payable to the trust, your rental property, your LLCs, or your corporate stock, everything. You got to take those things, those passengers, and put them on the train. Now, so what we see, two different things. What we see, and again, for all of your viewers, a takeaway, is one, we will see that they went and they took some time, they sat down, they did a will, they did a trust, they did healthcare directives, they did powers of attorney, they did all that, maybe even done it with a lawyer rather than with LegalZoom. And then, well, it happens. For some people that really can't afford a lawyer, I think LegalZoom is a good idea for better than nothing, but it doesn't really do the job. So and maybe sometimes it could even be worse. But the scenario here is that they have in the back of the trust, there's like a sheet, it's called schedule of assets.
Right.
They list all their stuff on the back of the trust. And they believe that is the transfer into the trust. That is not. You could put, 123 Elm Street, my residence, on that schedule. Unless the deed has been changed from Valerie to to Valerie's trust, it does not avoid probate. So that's one. So the long list of assets doesn't mean anything. It's illustrative for someone to search for those, but we're looking to see whether or not those assets have been transferred to trust. For everyone that does, we have avoided the probate process. And what do we typically see? We typically see that people have 25, 26 assets. I'm just picking a number. And then we'll find when we go through, and they did do some estate planning, and we find that the 22 of those assets have successfully been transferred into the trust, and 4 of them have not. All right. No one took an inventory. No one took a deep dive. No one took a deep look. They had a home. They refinanced the home. The bank made them take it out of the trust. They never put it
Right.
back
Yeah.
in the trust.
Absolutely.
And then we see that those assets, those 4 assets that are not in the trust, have to go to probate. So now I have a trust administration administering the 22 assets that are in trust, and a probate over the 4 assets that are not in trust. I didn't avoid it. The other thing too, that's interesting that a lot of people don't recognize. So we want to make sure that, so we see those dangling participles. So one of the things that I think is really important is, not only to have great estate planning documents that really do the job, but to make sure that the assets line up properly inside that document, and that the document's not just a clinical document, but a testament to the family's culture and values. A little bit more time, but really well worth it.
Yeah.
The other thing that people don't recognize, and today we have a lot of people that own properties, Valerie, in more than one state. So they'll have some
Right.
properties in
Yeah. And we're
California,
one
and
of those. Yeah. We're
yeah,
one of those. You're
and they'll
helping
have
us with that. Yep.
vacation property in
Yep.
Arizona, or they'll have
Or
a
Tennessee or Florida
condo
or
in
yeah. Yeah.
Tennessee or Florida, wherever else it may be. And what a lot of people don't realize, which they will realize now by listening to your show, that if those assets that are real property in states other than your home state are in probate, it's another probate. It's an ancillary probate. So we had property in California, a property in Utah, and a property, let's say, in Arizona. Die. I have a probate, and it's not in trust. I have a probate proceeding in California. I have another probate proceeding in Utah, and I have another probate proceeding in Arizona. I have 3 probates. Those are called ancillary probates. Oh my God Almighty! And then to find that out afterwards, the children to find that out afterwards, or a surviving spouse to find that out afterwards. Oh my God Almighty! Just fireworks are going off, because can you imagine the expense that's associated with that and handling multiple probates? Now, had they built a trust, good trust, and then they put the legal transfer of those 3 properties into the family trust, no probate at all. No probate in Utah, no probate in Arizona, no probate in California. This is critically important. And we see that all the time. And
Especially now that, and I don't mean to interrupt you, but now so many people over the past few years have purchased properties in various states,
yeah,
right? More so than ever.
yeah, and the reason for since COVID, and the world has become connected via video,
Yeah.
people who had to work, for example, in LA, now can, when they're in LA, work in LA, and when they're in Utah, they can work in Utah, for their LA office in remote working. And so there are many properties that are purchased outside of California where they're more affordable than they were, or environmentally they're happier than they were with their main property in California. So sure. That's important to understand. So that's the difference between a will and a trust. The will is a letter of instructions to a probate court judge. We're going to probate. A trust avoids probate as long as the passengers are put on the train.
In the right place.
Hmm.
So why do so many people procrastinate on estate planning? It's the gentleman you're talking to that's multimillionaire, and I think I heard you on another one of the sessions I listened to, was that someone just they just didn't think it was important and they just avoid it, and
Yeah, well,
then they
I don't
call
think
you afterwards and say,
I don't
"Oh,
say
by the
that
way."
that's the asset protection issue. So let's just stay on the estate issue for a second. The estate is Gen 1 to Gen 2, incapacity, privacy. asset protection is protecting our assets from the claims of third-party creditors. We'll get there in the back part of our interview today. But so why do people don't do it? Okay, so let's start with the obvious. Um, Quality legal work is not cheap. All right. Quality legal work, not because we want it to be expensive, but it's very expensive for us to run our businesses.
Sure.
Lawyers are expensive, our rent is expensive, our insurance is expensive, everything. Our employees are expensive. It's an
Court
expensive
fees. Yeah.
business. It's an expensive business to run, and it's reflective in the fees. When a lawyer charges X fee, we don't keep 100% of it. Maybe we could drop 10 cents or 15 cents to the bottom line. 85% goes in overhead. But so one is cost. So some people, not all, some people, cost is a non-issue. For some people, it's cost. They hate paying legal fees, and so they procrastinate for that reason alone. So that's one, cost. Not the biggest reason. The bigger reason
Mm.
is um, sticking one's head in the ground and failing to, it's very difficult for many people to deal with their own mortality. It is uncomfortable. It's uncomfortable to talk to an attorney about their wayward child. It's difficult when there's distrust between spouses. It is difficult when you have a child that has a spouse that we don't like. All right. And they were concerned about that. It's difficult if we have a child that has special needs. All right. That's autistic or has other problems. It is difficult to deal with aging and Parkinson's and Alzheimer's and all of those long-term debilitating. And all of this comes up in that process. It's difficult to talk about the estranged sibling. All right. All of these things tend to come up during the estate planning process because the estate planning process isn't just about death. Remember, it's the healthcare directives, it's the
Right.
powers of attorney, it's what happens in the event of my incapacity. Now, the chances of incapacity are 15 times greater than death. All right. So we have to make sure that our documents deal with incapacity and our wishes and concerns, which is an interrelationship between the trust, the healthcare directives, and powers of attorney. Without those things, we're back in court. Just called a conservatorship, man. It's a living probate. It's awful. It's expensive, and once again, it's in the public domain. So I think that you have psychological reasons for that. And then you have the other one, which hopefully shows like yours will dispel these rumors. People think that, for example, in basic estate planning, that somehow they're going to lose control of over everything that they've worked all their life to build. If I put it in a trust, it's going to be controlled by a trustee and not me. If I need to get a bank loan or refinance my property, it's going to be difficult. I can't, blah, 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 blah. It's not true, but they believe that is to be true. So it's expensive. It brings up difficult thoughts in one's mind of our own demise, of our own incapacity, of our own interfamily relationships. All right. And and then the other thing too that happens, the reason that people procrastinate is that some people are just by generally they're indecisive. So what happens is that for example, if you have a younger couple, like the children of the people that we're talking about today, who may have younger children, and one spouse thinks that sister should be the guardian, the other spouse thinks that his brother should be the
Yeah,
guardian,
sure. I
and
know.
that doesn't lead to a very interesting dinner conversation around the
No.
table. So since they are at an impasse, they can't. Your brother's an ass, your sister's a jerk. We don't want them to raise our children. Look how they raise their children. This is
Heard
uncomfortable.
those
Oh yeah,
discussions.
this is uncomfortable.
Yeah.
And what they don't recognize, critically important, is by their indecision, the decider of who's going to be the guardian for their children is the state of California.
Yeah.
So if they're worried about brother or sister, state of California can put a real beauty in
Yeah.
there
Sure.
to
Yeah.
get it done, and it's a long, laborious process. So everyone has to understand, walking away today, indecision is a decision to let the
Right.
state make a decision for you. So,
Yeah.
everyone wants to take the law in their own hands. This gives them an opportunity to take the law in their own hands. But that's the reasons why. It's uncomfortable, it's expensive, it takes time, and people are indecisive. Now,
But it's irresponsible. It's just
it's also
irresponsible.
definitely irresponsible. And but also there's an interesting phenomenon that once people are into it, okay, and they're working on their planning, here's what I hear. I feel so much better now that I have that in my rearview mirror. I feel better. I could sleep. The words are, I could sleep better at night, knowing that all of that is worked out. So, so once people are into it, and the other thing too is, not being pretentious or self-serving. It's also the choice of their professional that's helping them. Some people are just absolutely downright clinical. They're not very compassionate towards their client. They don't think outside the box. They're trying to, you know, get it done as quickly and efficiently as they possibly can when you're dealing with, I think, the most important contract in their life. So I think that the selection of an appropriate practitioner to help you and all the other factors really make that so much better.
Something I found with your practice, and this, I don't want to make this a commercial, but since you bring that up, is that, for the benefit of the audience, we have, I guess, for disclosure purposes, we have started to work with you, and we were surprised the little amount of pressure that you put on us. In fact, once I called and they said, "Well, we don't pressure you. When you're ready, we're ready." And so it's not like a TV commercial or radio commercial where, come in now and you'll have a trust in 20 minutes. Now we could have, but I think it's important. And so the point of that is it's important that I realized that we do see so many commercials, right? And everybody's now got an attorney that's pushing that you should do this and do that. And when you're ready, there's no need to be pushed because it's not necessary. Although it is urgent.
Mm-hmm.
Is urgent, but I
Absolutely,
don't. I
absolutely.
think
So Valerie, if you're ready, I think we should, so just everybody knows the document, just to repeat, the documents in the state healthcare directives, as we talked about earlier, critically important. Powers of attorney to avoid conservatorship, who makes financial and property decisions if we're unable, a will as a backup document to a trust, and an appropriately, properly designed family script known as the family trust, and then making sure the passengers are on the train. I think that that's a great takeaway for the first, 3/4 of the time that we have together. But I'd like to, if it's okay with you, you're the boss. Um, I want to talk a little bit about some of the misconceptions about asset protection. Um, because to me, it's critically important that we protect our assets. We live in a very, very challenging world
we do.
where everyone's litigating about everything. We see all the signs on the billboards, when we drive on the freeway. It used to be at night we'd hear Cal Worthington talk about selling you a car. Now at night, all we see is personal injury
Right.
lawyers,
That's exactly.
Sweet
Yeah.
James, Eaton and Eaton, this one, that one, all of them, Law Brothers, Russ Brown, you go down, call Russ Brown. I mean, if the
Right.
motorcycle,
Exactly.
it's all of this, now culturally, um, everybody's suing everybody about everything, and so therefore, I think it's critically important that we also assess our vulnerability from an asset protection perspective. And this is some of the things that you were talking about earlier. And the main takeaway here is you don't do it after the event has occurred. You described that earlier in our interview today. You know, something happened. I crashed the car. I injured people. I got $1 million worth of insurance. If I even have $1 million worth of insurance, and this is going to be way north of $1 million, sadly, we didn't want it to happen. It's but we got it, and it maybe be $2.5 million or $3 million. I got $1 million worth of insurance. Where's the other 2.5 million going to come from? We feel terrible about what happened. But now, can we lose our house? Can we lose our bank account? Can we lose our properties? Can we lose? Do we lose our pensions? What happens to us here now? And so what happens is they look up, where they are, or they call their friend, and they find out that BarthCalderon, we're asset protection attorneys. They call us. This is what happened. Can you help us? Okay,
Right.
you were spot on there. So let's talk about that for a second.
Yeah. Actually, that's my next question here is why should the average person care about it and what really works?
Yeah.
How do we
So
protect our assets? Why should and the thing that you hear as well as I hear is that, well, I really don't have that much. Right? I
yes.
really don't have that much money. I really don't need to have an attorney to help me with my asset protection. Why should we
Oh,
spend the
and
money?
and so, and sometimes that is correct. You're right. We don't have assets to lose. We really don't need to do asset protection. So, but people, that's an interesting variability. And then I'll talk about some three axioms of asset protection. But let's
Great.
talk about that variability by giving you an example of something that happened. One of a thousand cases that I could talk about today. But let's talk about one that really hits home a little bit. So we
Okay.
had a client. It wasn't our client at that point in time. Two retired school teachers, and the two retired school teachers, after a lifetime of teaching, were left with basically two assets. They each had a CalPERS account,
Okay.
the
Right.
CalPERS account from all their years of teaching, and they had their home, which I think was at that time, it was in Brea. And their home, like most homes in California, had appreciated quite significantly. Um, they had bought it for $400,000, 20, 30 years ago, and now that home was $1,800,000, $1,900,000. They had virtually no mortgage on the property, and that was all they got. That was it. At $1,900,000, and they didn't feel that they, as two retired school teachers, had very much liability. um, there was it's tough on a budget, so they had automobile insurance, but their automobile insurance was the minimum that they could buy. A liability, I think at that time was 1525, so
Sure.
15,000 per accident, 25,000. I mean 15,000 per person, 25,000 for an accident. It goes back about 20 some odd years ago. And the wife was pulling out of a shopping center on Imperial Highway, and there was a lady that was walking with a shopping cart, and she hit the lady uh, with the shopping cart. And I mean, and that lady was, I would say, not major injuries, but injuries. I would say, in between minor and major injuries. And um, it was her fault. I mean, it was the client's fault. Didn't see her. They should have seen her. They were pulling out. She was going to cross on the crosswalk, and they just hit her. Unfortunate. And they were sued by that lady. She got one of the billboard lawyers,
Yeah.
and it was an interesting result. She didn't get a lot of money, but she got $300,000. All right. They had $15,000 worth of insurance for that accident. So that left $285,000. Where was it going to come from? Well, their
Wow.
CalPERS accounts were safe because they were pension plans. They were safe under California law.
Okay.
And at that time, the homestead exemption was $100,000 for the amount of equity in their home. And so they lost their home. Their home was literally sold. They didn't have any income. They couldn't refinance the house. Interest rates, they literally, the home was sold and 285,000. They got $100,000. They got everything above. They, the plaintiff woman got got the $15,000 from the insurance company and $285,000, but cost their home. Wow. What could they have done differently? Which is one good question.
Good question.
Now, now, did they need a large asset protection plan with super duper trusts and LLCs? No. Did they have some opportunity to uh, do some things to protect their home? They did. But what they really needed more than anything else was someone to take a look and say, you didn't have adequate automobile insurance or homeowners insurance. If you would have had a
Really?
$1 million umbrella policy, so you jack the limits to 100, 300, all right, for your automobile insurance, for $129, you could have added $1 million umbrella policy. All they needed was adequate insurance. They had inadequate insurance, and that was their asset protection faux pas. And then we would have been okay in this scenario. And if they had come to us beforehand, all right, we would have looked at that and said, well, you don't need a whole lot of sophisticated asset protection tools, but you really should go to your agent and increase your liability insurance because what you have is inadequate. It's good enough. Would
And
have
you would
worked.
have helped them with that?
Sure. We would have said, thank you very much for coming in. There's no charge for that. Could the insurance agent. And if your insurance agent doesn't understand that, we could recommend an insurance agent for you. But that would have been, I just wanted to show people that would have been a simple solution to a potential liability and problem. So what are the three axioms here? Let me give you the three axioms, Valerie. So in the asset protection arena is good quality professional asset protection. And remember, we all want to protect our assets, every one of us, and nobody wants to give them away,
No.
is to get those things looked at, analyzed, and protected before any liability arises. Now, when I say that, when those words fall upon your listening and viewing audience, they may misinterpret that. So let me help an explanation.
Okay.
It's not when you were sued. It's not when you are threatened by the lawyer. It's when the liability occurred. You might not see a liability for a letter from a lawyer for a year afterwards. It's when that car hit that lady with the shopping cart. That is the date. So anything we've done post that date, our remedies are less than adequate. Doesn't mean, Valerie, that there's nothing we can do to help people. We can. But they become speed bumps and not roadblocks. All right. So, but speed bumps are sometimes helpful. The next admonition that's very important is we were talking for the first part of our time together today about living revocable trusts. Family trusts, they're a very critically important document, but your audience needs to know that living revocable trust provides zero asset protection. It's a great estate planning tool, avoids probate, but living revocable trusts have no asset protection. A lot of people think, well, I got a house in my trust, it's safe. No, your house is not safe in the trust, not in that type of trust. And the third thing is we have insurance for that. We bought insurance for that. Insurance, as we now know, is a critically important part of asset protection planning, but it's not the know-all end-all. There are more holes in those things than Swiss cheese. All right, insurance companies are not necessarily your friend. So it's the combination of legal procedure with appropriate insurance that gives us the ability to sleep better at night.
Yeah. These sound way too familiar. We've had some of these discussions, and I'm sure that our listeners and our viewers have also. Unfortunately, we have run out of time on this show, but we certainly would love to have you back and hope that you will come back. And we're going to talk to you about being at our community workshops as well, so people can come and meet with you in person. We want to give you the opportunity to tell us, how can people find you, and are you available to people on the phone if they can't come to you personally?
Yes. We're available by phone. We're available by Zoom. We're available for them to come in. And the way to reach us, very simple, is you can just do email to harry@barthattorneys.com, or they can call our office at 714-704-4828. And we have a whole team that will be there to help them answer their questions or book appointments that we need with myself or a member of my team.
Great. And I can say that there is no pressure here, but they are extremely helpful, and you'll want to give them a call and talk to them. Thank you very, very, very much. Until next time, everyone, please be bold, not old, and be always ageless. And please do watch. This episode will be on our YouTube channel, and we'll have it available for the Barth attorneys to use in their publicity as well. Thank you for joining us today.
Thank you, Valerie.
Harry
Great
Barth.
to see
You are
you. Give
amazing.
my love to your husband.
Yes, I will. Thank you very much.
Take care. Bye-bye.
Bye.